or vote for Amen or Calabar. The Lord parties are absent.
You say? Claimant in court.
Claimant is in court. Defendants are all absent.
We are present.
We are present.
My Lord, we are present.
No, wait. I have not asked you to announce appearance.
Okay.
Yes, appearance. Yes.
Yesterday, I had some itches. So knowing that my body started better to form so that
It's all right. Yes, announcement, appearance for the dependents. Any appearance for the dependent?
Yeah,
We are present. Alfred is present for Ladi Lapo.
Mayor Campbell is present. Ex-president of the cooperative.
I can record if I cannot see your face. If you want to be recorded, you must make your face available.
okay, my Lord.
Please, let's.
Counsel online. Whom are you appearing for?
This is started. Start video.
Counsel online. Whom are you appearing for?
Hello,
are you not
sir.
hearing me?
Hello, sir. Our barrister
Yes.
is having network issue. I just having network issue.
Well,
Sorry,
if
sir.
I cannot hear him, how can I record him? I can record him if I can't hear him.
Okay, we'll
Is
soon
Miss-
log in,
what-
sir. He's having
is-
network
is
challenges.
Miss-
I just called.
Is Mr. Alfred Obo? Who
Yes,
is
I'm present.
Alfred Obo?
I'm present, my lord.
My phone is online, yes.
Who is Amin Akembo?
I'm present, my lord.
Okay. This matter is for ruling. The ruling of the court is ready. I will read it shortly. This is the ruling of the court. On the 23rd day of March 2023, this court took argument in respect of motion on notice dated the 7th day of February 2023 and filed on the same date. The motion on notice prays for an order of interlocutory injunction restraining the defendants. On the 8th day of April 2023, when this matter came up for ruling on the application for interlocutory injunction, the court informed parties that it is raising issue suo motu, issue of jurisdiction suo motu. Consequently, parties were ordered to file addresses on the issue of jurisdiction of this court to entertain this case. On the 5th day of May 2023, the counsel for the claimant, in compliance with the order of the court, filed his written address on jurisdiction. However, the defendant, despite having been served with all the processes filed before the court, failed and neglected to file defendant's written address on jurisdiction. On the 25th day of May 2023, IJ Umiandie, Esquire counsel for the claimant, while leading OE Kuku, adopted the written address of the claimant on jurisdiction. In the written address, a single issue was formulated for determination to wit whether this honorable court has jurisdiction to entertain this suit and hear the application of the claimant for injunction. In arguing the sole issue, counsel submitted that in order to determine the extent of a court's jurisdiction, the proper place to look at is the enabling law setting up the court and comparing it with jurisdiction. Counsel relied on the case of medical and health workers versus Idigbe as to support his submission. Counsel also refers to section 254A and 254C of the Constitution of the Federal Republic of Nigeria 1999 as amended. Counsel specifically relied on section 254C1A of the Constitution as amended and submitted that it is evident that this court has jurisdiction to hear and determine all the matters arising from workplace, including covering welfare of workers. Counsel insisted that this provision is very clear and unambiguous, particularly considering the clause matters arising from workplace. According to counsel, this connotes every matter or subject provided such matter or subject matter arose from workplace as in the instant matter. The provision also specifically identifies matters of welfare of which, again, the claimant's issue hearing falls into. This is because the loan fell under the welfare cooperative arm of the dependent, as shown in the claimant's letter of 1st October 2022 to the defendant through one IK attached to the complaint as one of the documents to be relied on by the claimant in this suit. It is long settled principles of law that once the provision of a statute is clear and unambiguous, no extrinsic interpretation should be employed to defeat the clear meaning of the provisions. In support of this submission, counsel relied on the case of First Bank of Nigeria versus Mayweather. He also relied on the case of Williams versus Williams and that of Ishola versus Union Bank of Nigeria Limited. Counsel also refers to the case of medical and health workers versus Idigbe, where the Court of Appeal held that jurisdiction of this court covers claims of defamation. Counsel urged the court to apply the provisions, the principle enunciated in the decision of the Court of Appeal in this case. On territorial jurisdiction, counsel submitted that this court has jurisdiction in support of this contention. Counsel relied on section 21 of the National Industrial Code Act 2006 and Order 2, Rule 1 of the National Industrial Code Civil Procedure Rules 2017. Counsel submitted that in this case, two of the defendants are having place of business in Calabar at 58 Idigbe Road by Avua Mayan Duke House, which is nearest to the registry of this honorable court and where the subject matter leading to the suit took place. Counsel submitted that it is tried court shall have jurisdiction to hear and determine any suit for specific performance or any suit founded on breach of contract if the contract was made within the jurisdiction of the court, though the breach occurred elsewhere, or if the breach occurred within the jurisdiction, though the contract was made elsewhere, or if the contract ought to have been performed within the jurisdiction, or if the dependent or one of the dependent reside or carries on business within the jurisdiction of the court. Counsel submitted that all the conditions are in favor of jurisdiction of this court. Counsel urged the court to hold that it has jurisdiction to entertain this court as it is presently constituted. This is the decision of the court. Let me start by saying that the second leg of argument by counsel for the claimant that on territorial jurisdiction of this court has no relevance whatsoever to the issue raised suo motu by the court. The issue raised by the court is in respect of the statutory and constitutional jurisdiction of this court to entertain this matter or not. Well settled law that issue of jurisdiction can be raised at any stage with or without leave of court, and even for the first time on appeal before the Court of Appeal or Supreme Court, it can even be raised by the court suo motu as was done in the instant case. The issue of jurisdiction of a court to try a suit is a fundamental and threshold one. The rationale for this position is that any proceeding conducted without jurisdiction are a nullity and liable to be struck out, no matter how well conducted. Jurisdiction is extrinsic to the adjudication. If a court has no jurisdiction to determine a subject matter of the suit, or that the parties are not subject to the jurisdiction of the court, the proceeding thereof remain a nullity, however well conducted, and the judgment, no matter how brilliantly written and eloquently delivered. It behoves on every court to decide on its jurisdiction to see whether the issue sought to be ventilated before it are within its jurisdictional competence. In essence, jurisdiction is radical and fundamental prerequisite for adjudication by the court. See the case of Madukolo versus Nkendilip. See also Attorney General of Lagos State versus Dosmo, and host of other cases cited therein. It must be noted the jurisdiction of court does not exist in vacuum, as all courts of law derive their jurisdiction from either the Constitution or statutory provision establishing the court. Therefore, no court can assume jurisdiction without having been constitutionally or statutorily being empowered to do so. See the case of Boko versus Nwangwa, and that of Lekot versus Judicial Tribunal. See also the case of Bot versus Just Electricity Distribution PLC. It has been settled by a long line of decided cases that a court is competent when it is properly constituted as regards membership and qualification of the members of the bench, and no member is disqualified for one reason or another, and the subject matter of the case is within the jurisdiction, and there is no feature in the case which prevented the court from exercising its jurisdiction, and the case comes before the court initiated by due process of law and upon fulfillment of any condition precedent to the exercise of jurisdiction. Thus, any defect in competence is fatal, for the proceeding are a nullity however well conducted and decide the defect is extrinsic to the adjudication. See the case of Madukolo and Ingetle Supreme. In determining issue of jurisdiction, a court is enjoined to look at the claim of the claimant. In the instant case, the claimant's claim is what the court will consider to find out whether the claim is within the purview of the jurisdiction of the court as donated to it by the Constitution and statutory provision establishing the court. See the case of Omora versus KRPSC Limited. See also Edison Automotive Limited versus NAPON. Paragraph 23 of the claimant's statement of facts encapsulated the claims of the claimant against the defendant in this suit. The said paragraph is hereby reproduced for proper appreciation. It reads, and whereas the claimant claims against the defendants jointly and severally as follows. 1, a declaration that funds in the claimant's account domicile with the second dependent is enough to satisfy servicing of the loan granted to the claimant. 2, a declaration that the dependents were wrong in proceeding against the claimant's guarantors and deducting funds from the claimant's guarantors' accounts in connection with the loan to the claimant. 3, an order directing the dependent to credit all funds debited from the claimant's guarantors' accounts as a result of the loan to the claimant. 4. An order for tabulation and payment by the defendants of the balance or all the monies accrued to the claimant. 5. An order for payment of general and exemplary damages in the sum of 10 million naira against the defendant jointly and severally and in favor of the claimant. 6. An order of perpetual injunction restraining the defendant, their previous servants, agents, personal representatives, assigned and administrators from harassing the claimant or the claimant's guarantors on account of the loan advanced to the claimant by the first defendant. 7. An order for accrual of 10% interest on the judgment sum from the date of judgment until total liquidation. Above are the reliefs being sought by the claimant in his claim. And for the jurisdiction of Section 254C of the Constitution of the Federal Republic of Nigeria as amended provide as follows. I have quoted the provisions of Section 254C of the Constitution, which provided for the Constitution of this court. So I shall speak, I will skip reading the provisions. Council will have the benefit of seeing those provisions once they collect the hard copy of this ruling. The elaborate provisions quoted above compass an extensive and unambiguous exclusive jurisdiction on this court. Therefore, the court is both a court of first instance and an appellate court. The jurisdiction of nexus inextricably linked or reasonably connected to subject matter over which jurisdiction is conferred in Section 254C. The jurisdiction of the court relates to the ramification of labor and labor relations in its length and breadth. Insofar as it concerns labor, in view of the foregoing provisions of the Constitution, what this court is saddled with the responsibility is to see whether the claimant's claim comes within the purview of Section 254C of the Constitution as amended to confer this court with jurisdiction to entertain this suit. To be able to decide the issue of the jurisdiction of the court, the claim of the claimant is encapsulated in the general form of complaint, and the statement of facts are the relevant materials this court is to consider. This is because generally the nature of the dispute between parties and the set of facts giving rise to the dispute should naturally determine whether the court has jurisdiction in a particular matter or not. The brief facts which necessitated institution of this suit, as can be gleaned from the pleadings of the claimant, is that the claimant was the employee of the defendant and a member of the first defendant multipurpose cooperative society. The first defendant has a loan scheme for its members, and the claimant, while he was branch manager of the second defendant in September 2021, obtained a loan in the sum of 1.2 million with a tenure of 30 months and the interest rate of 5% per annum. The transaction was to terminate in 2024, and deduction for the services of the loss commenced in October 2021. As at the time the claimants left the services of the second defendant, some deductions have been made from his salaries to the tune of 405,000 naira from October 2021 to June 2022 for services of the loss. But since the disengagement of the claimant, the defendants have been harassing his 3 guarantors to the loan agreement, and the defendants have separately deducted various sums from the claimant's guarantors staff salary accounts maintained with the second dependent every month in the guise of recouping the loan granted to the claimant, and have insisted on continuing with the deduction. All entreaties for reconciliation fell on deaf ears. The counsel for the claimant heavily relied on the Court of Appeal decision in the case of Medical and Health Workers Union of Nigeria versus Dr. Alfred Ehabwa, reported in 2018, LPLR 44972, Court of Appeal, in urging this court to hold that it has jurisdiction to entertain this case. However, this decision, the decision of the Court of Appeal, this decision of the Court of Appeal held that this court has jurisdiction over the defamation. The case is not on all fours with the case at hand. Now it seems the Court of Appeal has changed its position in the case of EcoBank Nigeria Limited and others versus Idris, reported in 2021, 52806, Court LPLR 52086, Court of Appeal. The Court of Appeal has held that in this case, that this court does not have jurisdiction over defamation. Having regard to the above position of the Court of Appeal, and also taking into consideration that this case is not on all fours with the above cases decided by the Court of Appeal, this case will be treated on its peculiar facts and circumstances. A careful examination of the factual situation giving rise to the claim as contained in the claimant's pleading will show that the claim as anchored are based on loan granted to the claimant by the first dependent. The mere fact that the loan granted to the claimant was while he was a staff of the second dependent does not bring the said transaction within the ambit of workplace or welfare as contained in section 254C1A of the Constitution as amended. For the claim to come within the jurisdiction of the court, it must be shown that the claim relates to or is incidental thereto or connected with any labor or employment dispute. That is to say, the subject matter of the dispute must be within the purview of section 254C of the Constitution. From the reliefs and the entire pleadings of the claimant, there is nowhere labor or employment dispute was disclosed. Therefore, the claim before the court is not within the purview of the provisions of section 254C1 of the Constitution of the Federal Republic of Nigeria as amended. The dispute between the claimant and the dependent is that of loan granted to the claimant, and not dispute in relation to labor or employment, or relation to workplace, or in relation to welfare of the claimant as employee of the second dependent. In the circumstances, this court lacks the requisite jurisdiction to entertain the claim of the claimant before the court, as there is no dispute on labor or employment disclosed by the claimant that is related or connected to his employment or that is connected to labor or employment, or even his welfare as staff of the second dependent, or as regard to workplace in relation to his employment with the second defendant. I shall therefore, in view of this finding, I shall refrain myself from making any pronouncement on the motion on notice which was argued on the 23rd day of March 2023 for interlocutory injunction against the defendant. Since this court lacks jurisdiction in this case, in this matter, as I do not, therefore I do not have the bias to to pry into that application or to make any pronouncement regarding the praise contained in the application. In view of the foregoing, by virtue of the provisions of Section 24, subsection 2 of the National Industrial Court Act 2006, this suit is hereby transferred to the High Court of Cross River State as the appropriate court having jurisdiction to hear and determine issues with relations to loan. This suit shall be forwarded to the Chief Judge of High Court of Justice of Cross River State for assignment to a judge of the court who shall hear and determine the case appropriately. Ruling is entered accordingly. I make no order as to cost. Parties to bear their respective cost.
As the court pleases.
As the court pleases.
Particularly for the wife, it is said that the law is in the best of my law.
It's all right. You are welcome. Yes, registrar, any other matter? Okay, thank you, counsel, for being with us and all those who joined virtually. We have come to the end of the virtual proceedings.
Thank you, my lord.
We are all free to leave.
Thank you, my lord.
Administrator, you can end